Hello and welcome to Legal Reader. I'm your host, Mike Gassaway. Today I have a special guest on the program, Andrew Traub, whose personal injury law practice in Austin, Texas is focused on getting injured Texans the care and compensation that they deserve. Andrew's a friendly and approachable attorney to clients, but a vehement fighter. I mean, he is ferocious, people, when it comes to dealing with the insurance companies. Andrew, welcome, and thank you for joining us.
Hi, Mike. Thanks for having me.
I appreciate it. I'm excited about this interview. Let's start off by you bragging about a little bit about yourself. Tell us about Andrew Traub and, your education, your law practice, that kind of stuff.
So I guess I was born in Johannesburg, South Africa. And when I was almost 6, my family moved to Toronto, Ontario, Canada, became a Canadian citizen. When I was about 13, we moved to Dallas, Texas. Became a U.S. citizen when I was just finished my freshman year in college at UT in Austin. Then went to law school at UT Austin, and I've been here ever since 1988.
Well, you got to Texas a little late, but you're glad you're here, I suspect.
Absolutely.
And tell me a little bit about your practice.
So our practice is focused specifically and only on personal injury law. So, that means automobile accidents, motorcycle accidents, truck accidents, dog bites, and slip and fall cases are the majority of the cases we do. If someone has a medical malpractice, we don't do that, but we refer those out to partner attorneys who handle those kind of things.
Same way with products liability, or do you keep those in-house?
No, we also refer out product liabilities case. We did that for one client that had a defective vehicle where the car rolled onto him. Both product liability and medical malpractice are real specialty areas. They require a lot of specialists that we don't generally affiliate with and know about, and a lot of experience to know how to develop those. So those two areas we don't do. It's just really mostly the ones that I already mentioned.
I got you. And are you a sole practitioner? Are you in a firm, a partnership, or kind of what's the deal there?
So I am a sole practitioner. The firm was started, even though I graduated law school in 1995, I didn't actually start the firm and practice law until 2003. And I've been sole practitioner ever since then, with the focus on personal injury since about 2007. Did spend the first few years doing like contract law, real estate, estate planning, some bankruptcies, some divorces, and I never really took to any of those. But I really did take to personal injury because we're really helping people fight these big insurance companies. So it's really kind of helping the underdog, and it's really rewarding to do that.
Andrew, what initially drew you to the practice of law?
Well, to be honest, my parents. My father was a lawyer in South Africa. He was a top lawyer. Once we moved to Canada, he couldn't practice anymore because it's a different type of law. He had 3 children to support, and so he really couldn't go back to law school. And so what ended up happening was he went into something else. And it was always kind of one of the things, I guess since I was a kid, my parents would always say, oh, and people as well, who didn't know about, my dad's background, would always say, oh, you're going to be a lawyer when you're older. And, when I graduated college, I just naturally went into law school. But my heart was in business. That's what I had studied undergraduate. And so when I finished business school, I actually started a computer business. It was a little white box sort of manufacturing computer company. Ran that till 2001. Then did software consulting for a year. Then did some software development for a half year. And then, ultimately started my law practice. And figured out really what drove me in the law practice, what I could do best. But it's always been about helping people. Even when I had my computer business, we were known and our reputation was built on helping people and good quality service, and that's always been our goal, is to help people, regardless of, what we're doing. It's to help people with, whatever their needs are.
Tell us a little bit about the personal injury practice itself, kind of the essentials of personal injury practice and what it takes to take a case from a client walking in the door till the time you give the client his check.
I mean, that's a lot of work. Most cases don't
Yes, it is.
very quickly. So, I mean, when a client comes in, we interview them. Um, it has to be the right fit for them and for us. The case has to be the right type for us, where we feel we could add value. If someone comes in and they just went to the doctor once, they don't feel like they're going to go much more, or they're on prescription medication and they don't think they're going to need anything further than the prescription medication, we can't add value to them. We're not going to be able to get them a better result than they can do on their own. So in that case,
Right.
we're going to refer them out, or just really tell them we can't, we feel that they're probably better on their own. Sometimes the clients will come in and for whatever reason, they don't want to get more treatment, even though they may be somewhat more than just a bump of an injury. If a client doesn't want to get treatment, even though they clearly need it, that's not going to work well for us either, because we want clients that are going to be active and getting into getting treatment. They want to get better. We want clients that are trying to get better. We don't want clients that are going to be just kind of sitting around and making a big complaint, but not really trying to do better. So we kind of screen for that. So if the client likes us, we feel we could add a value to them, then they retain us. And then it depends on their treatment status. Sometimes they might come to us and the accident's been a year and a half and they're done with treatment and they don't think they need anything more. Or they might be really early in the process and we don't know what kind of treatment they're going to need. And so it kind of depends. Do they have health insurance or not? If they have health insurance, we kind of tell them, go ahead and use your health insurance, go to your family doctor, see who they refer you out to. If they don't have health insurance, then, we kind of try to have to refer them out. What do they need? Are they needing, is it a neck and back? So they need to see a chiropractor or an orthopedist? Is there something else? And generally they'll go get treatment. And while they're getting treatment, we're going to do some work, but not most of the work. While they're getting treatment, we're going to order the medical records. We're going to order 911 records. We're going to order police reports. We're going to notify the insurance companies of our representation. And to some extent, we might guide them in the medical treatment in the sense that if the doctors aren't helping them and they don't know what to do, we might say, hey, maybe you need to see a specialist. Ask your doctor about whether they think you seeing an orthopedist might be beneficial, or a neurologist, or whatever the case may be. But for the most part, we're not super active. We do help them with property damage if they want it, if they need it.
Uh-huh.
But once they're done with treatment, that's when we really get active. Once they're done with treatment, we have to order their medical records. We get their medical records. We make a chronology. We make a timeline of their treatment, and we prepare that. And we prepare a demand letter based on their treatment and talking with them about what their injuries are. And we go beyond, of course, the medical records are going to talk about the injuries, but they're not going to talk about how they affect their activities of daily living, what it means for them at work to be in pain, what it means for them to be at home in pain. Do they have children that they can't pick them up? Does it interfere with their relationship with their spouse, their cooking, their hobbies, whatever the case may be? And so we find that out not in the interview up front, but also later on when they're done. And we prepare a demand letter, and then we send that to the client reviews it, and then we send it out to the insurance company, and hopefully they accept the demand and they, tender the amount that we ask for. If not, the insurance company comes back to us with another number, and we take that back to the client and we negotiate. And the client's involved in every step of the way there. And if it doesn't settle, that's the client's choice. It's the client's choice. Are we going to accept whatever they've offered, or are we going to file suit? If the client tells us, go ahead and file suit, then even more work starts, because we have to file suit, and that's a whole process in and of itself. That can take another year to two just to get to trial.
Mm-hmm. Let me ask you this. There are obviously two prongs to every personal injury case. The issue of liability as being one prong, and the damages is the second prong. Why don't you explain to the layperson, the viewer, what you do to evaluate both liability and damages as a case comes into you?
So in terms of liability, we have to prove that the defendant did it and caused the accident, and that the accident caused the injuries. And so usually there's not that much of a dispute on the accident causing the injuries, but let me start with the first one, which is causing the accident. So investigation generally means, obviously talking to the client and getting the police report. Those are our primary starting points. Sometimes, if there's witnesses available, we go and talk to the witnesses either by phone or in person. Just recently, I had to hire a private investigator because we found out there was a witness who may actually have had a video of the event. And this was a he said, she said, and the witnesses were on each side saying what happened. And so obviously video doesn't lie. And this witness had the video, but for whatever reason wasn't able to get it to us. We kept sort of being like ships passing the night. We just couldn't connect. We tried to get a hold of him. And so we hired a private investigator who went out, got a hold of him at his work or home and got a copy of the video, which makes all the difference for us. So generally, there's not a lot of he said, she said, but sometimes it does happen. We've taken on cases where there have been accidents at intersections with a red light. One person ran a red light, but both people are saying it's the other person. And if there's no witnesses, we'll possibly file suit and investigate. We have a case recently where the police cited the other driver, but there was another car traveling that was also involved in the accident, and that car swears that the driver that was cited was actually traveling beside him the whole way. So we've got a problem because the insurance company, even though the police report backs us up, the insurance company denied liability. And when we looked at the photos of the scene, it can kind of go either way. The photos can't tell us whether she crossed in front of the client or was traveling the opposite direction and somehow they veered into each other. But what we found out there was she actually worked just down the street from where the accident occurred. So logic would tell us that she came out and took the closest, fastest route, because the other alternative would have been for her to travel like 2 hours out of her way to go the way the other witness said. So there's investigation in terms of the liability. In terms of the accident causing the injuries, that's when you'll find that the insurance company will hire paid doctors who will say pretty much what the insurance companies want them to do. And there we have to be a bit more clever, and we have to really get into the nitty gritty of, how did the doctor make this determination that the accident, it caused the injuries, but, because I actually got a trial going in a month, and the doctor is saying, I agree that the accident caused these injuries, but only for 6 months, and any treatment after that is not related, which doesn't make sense because you say this person had this level of shoulder pain, of high shoulder pain, 9 months, a level 9 out of 10, and they're complaining of the shoulder pain for 6 months. And that's what you're saying, that it's due to the accident. But then she continues to treat and continues to have the same level of shoulder pain for another year and a half. But you're saying it's only related to that first 6 months. It makes no sense. So you're saying that the client went to bed at month 6 with the same level of pain that you said she had, and you agreed she had for 6 months due to this accident. But then the very next day she woke up with the exact same level of pain and symptoms, but now it's not due to the accident. I mean, it just makes no sense.
It's not attributable.
Right. It's just not. It just doesn't make sense. But that's what happens, and so that's what we have to do on the liability side.
Let me back you up just a little bit. Again, we've got viewers who are just people on the streets, just everyday guys. If you go to trial and a jury determines that your client is 20% negligent, do they reduce the jury verdict by 20%?
So yes, the way it works is they're given a questionnaire, and the questionnaire says, first question is, did the negligence of this person contribute or cause to the accident? Let's say it's a 2-car accident. And so you'll have the names of each of the drivers in there. And then the next question will be, if you said yes to both, then assign percentage of liabilities. If you said no to one of them, then you don't need to do that, because then obviously one person's 100%. So if you say yes to both, then you fill in the percentages. And if you say whatever's put on, if we're bringing the suit as a plaintiff, whatever is put on our client is reduced by the judge after the verdict. So if there's a 20% verdict, if our client is deemed to be 20% at fault, and let's say the award is $100,000, the judge after the trial will reduce that $100,000 to $80,000. However, if the client is 51% at fault, then they get 0.
They get zero. There you go. Okay. So almost a true comparative negligence as opposed to a contributory where if they're any at fault, they get nothing. But let me ask you this. In that regard, it was a long run for a short slide here, because where I'm going is, what is your advice to a client when they get out of the car, they've had an accident, and the other person wants to talk to you and get you to say, oh, I'm sorry, it was my fault? What do you tell a client in that regard?
Well, I mean, we do recommend, obviously, the first thing you should do is make sure everybody is okay. Passengers in your car and the other driver, right? You want to make sure everybody's okay. Call the police, possibly, well, call the police and they'll get EMS out there if somebody's injured. It's usually best to try and get the police out there to write a report. The police will interview all the parties and make a determination of fault. The client should never, in their excited state, if they can, admit to being at fault. Because that may not be true. They may not know all the facts, and they might think something happened, but that's not the case. Or
they're just kind, and they want to be kind to the other person by going, oh, honey, I'm sorry, it's my fault. Kind of something like that. A statement like that can get you in the hot water sometimes, can it not?
Absolutely. Absolutely. More often than not, though, I see the person who caused the accident knows that they caused it, and they're the ones apologizing to my clients. I can't remember the last time my client said, they apologized even though they didn't cause the accident. So I don't really see that very much. I would say if the other person is telling you that they're at fault, it wouldn't be a bad idea to get that on your phone, recorded, either video or audio, if you can, of them admitting that they're at fault while they're there and saying it. You definitely also want to get any witnesses' names and phone numbers, preferably addresses too, at the scene, because sometimes people say they saw it, you don't get their information because of the excitement, and then it's too late later on. It's very difficult to find them after the fact.
Solid tips there, Andrew. Let me ask you this. Are there any other industry tips that the lay person should be on the lookout for when they're dealing with an accident?
Well, a lot of people want to know about the property damage, and we have a lot of advice on our website for that. But basically, you want to start those claims right away with the insurance companies. The insurance companies want to take your recorded statement. I would not agree to a recorded statement. Just say, I'm agreeing to give you a statement, but not a recorded statement, and also not discuss your injuries. If they're going to ask you about the injuries, just say, well, I'm getting treatment, or I'm considering treatment, and don't say anything like I feel fine or I feel okay. A lot of times if you call in on the same day of the accident, you may not feel pain that day, but the next day or that night, you'll be in a lot of pain. That's very common, very, very common. And you don't want to be giving a statement saying you're not in pain, because you don't really know until, a day or two later whether you actually have symptoms and whether you're in pain. Some of the deepest injuries don't appear right away. And so that...
Now, I'm sorry.
Go ahead.
Go ahead.
So the biggest thing
in regard to property damage, people think, oh well, my car is the only property damage. Well, sometimes there are many other property damages in an accident, are there not? Like if your cell phone screen gets busted, or your eyeglasses get busted, or your gold watch breaks its wristband, things like that. Those are all property damage claims, also, aren't they?
Absolutely. So anything in your vehicle that was damaged, cell phones, laptops, whatever the case may be, if you got blood on your clothing, that is property damage. That should be replaced. Now, in terms of property damage, there's two different types, right? There's either the vehicle is totaled or it's repairable. If it's repairable, right, you can get it repaired at any facility you want. It doesn't have to be where the insurance companies want you to get it repaired. And while it's getting repaired, you're entitled to the lost value of the vehicle, meaning rental. So they have to either put you in a rental or pay you the comparable amount for that type of vehicle per day or per week for however long it's being repaired. And you're entitled to decreased value of the vehicle. So when you go to sell that vehicle later on, it's going to have a lower value, and you're entitled to get paid for that decrease in value that you're going to suffer when you go to sell the vehicle. If the vehicle
is that what you hear when somebody says diminution in value? Is that what that means?
Exactly.
All right. So we're talking with Andrew Traub here, a well-known personal injury lawyer here in Austin, Texas. Andrew, how does someone know when they need a personal injury lawyer?
Well, if you've been in an accident, it's not a bad thing to call and get advice from one or go online. We offer free guides on our website, but go online and find out what there is to know. Research who you want to speak to, and then call up some lawyers. Pretty much every lawyer that I know of who's in personal injury law will meet with someone for free. So there's no obligation, there's no fees to do that. So it makes sense to find out what your legal rights are. Certainly, if it's a serious injury, if you go to the hospital, you probably want to speak to a lawyer. If you stay overnight or have any broken bones or anything you might consider serious, then you almost definitely want to speak to a personal injury lawyer. If you didn't have any real problem, you refused ambulance service, the next day, you weren't really in pain, you don't think you're going to speak to a doctor, you don't think you're going to need treatment, you might want to hold off. But you don't want to rush into settlement either. The worst thing you can do is rush a settlement and get a case settled, only to find out now, all of a sudden, you've got a problem, a real serious problem, maybe that one that requires surgery. And then now, once you've settled, that's it. You can't go back for more. So I've had cases where a client once had low back injury pain, and they lasted for 2 years. And, you have 2 years to file a suit or settle your claim in Texas from the date of the accident. So around 2 years, we were trying to get his claim settled because that's what he instructed us to do. And we were negotiating, and they were offering something like $40,000 or $50,000, and we were trying to get them up to $100,000. And he said, "You know what? Hold off. I think I'm going to have surgery on this low back pain, even though it's really low. It's like a 1 or 2 out of 10. I just don't think I want to live with this for the rest of my life." And so we held off. We stopped negotiating. We filed suit because statute of limitations was running up. And he had this surgery, and we ended up sending the case for about $500,000. So,
Wow.
that's what can happen if you rush, if you want to wait till you're done with treatment before you settle. And so, big thing is, get the treatment you need and don't settle before you're done with treatment, or when you've reached maximum medical recovery, which is the doctor's way of saying you're not getting any better. You won't be at the level you were before. It's as good as it's going to get.
Good advice. Now you're here in Austin, Texas, and a lot of people don't know, but you're surrounded by Lee County, Williamson County, all these different counties that are within arm's length of you. Do you take cases out of Travis County?
Absolutely. We'll take cases throughout Texas. I'm licensed to practice in Texas, and I'll go anywhere in Texas. Now, obviously, the farther I have to travel, then we have to weigh the benefits and the risks. We can settle cases anywhere, but when we have to try them, we have to go to where either the defendant lives or where the accident occurred. So if it's really far away and it's really minor kind of accident, we're probably going to refer that out, tell you to go get local counsel. If it's a serious enough accident, we'll take it. Anywhere in Texas. We've had cases in Houston, in Dallas. I guess that's the farthest I've gone. I haven't gone to El Paso or really far out as of yet. But there's no issue with us going anywhere in Texas.
Beautiful. You'll go where the help is needed.
Correct.
Hey, now let me ask you this. You mentioned a $500,000 case there, and that made my eyes kind of swell up real big. Tell me about some of the big cases you've had and handled that kind of exemplify your practice, and some that where you fought for your clients and served them well.
I mean, so we've taken cases anywhere from $7,000 up to multi-million-dollar cases. We even actually tried a case last year where we were only seeking, I think, about $20,000 from the jury. Once we take on a case, we had the attitude, we're not just going to settle it if it's not fair to the client. We're going to take it all the way to trial if necessary, for the benefit of the client, because that's our commitment to our clients. We're not taking it on to just throw it at the wall, see what sticks, and then drop it. We see that a lot with, the TV attorneys. We don't take on, hundreds of cases at a time. We take on, about 70 cases at a time, not all of those, of course, in litigation. And so we want to give as much focus to each client as we can. So, we take on a broad spectrum. We just had a trial last week, actually. Our client was willing to settle in September because this is a particularly nasty defense counsel, but our client was willing to settle in September for 1/10 of what we actually recovered from the jury. because of the fact that she just didn't want to deal with it anymore. They were just so awful to deal with. She didn't want to go to trial, but they kind of forced us to with this lowball offer. And so we got a verdict, where the interest alone on the verdict is going to exceed what they could have settled for back in September. So,
Well done. And that was that the slip and fall case?
Yes, it was. In fact, from what
that's been big talk around here. Everybody's talking about it. It's a big deal.
From what I heard, it's
slip and fall cases. The slip and fall cases are historically very tough cases to prove and to get damages on, are they not?
Yes. I mean, the landlord lobbyists have made the law very difficult. In fact, we had a claim of negligence that we alleged, as well as premises liability. And negligence is a different standard. It's an easier standard. And our claim there was that because this what they did was they painted the sidewalk, and they painted in at about 10:30, where all the stores were open at 10, and they used something called quick dry paint, which which dries in 30 to 60 minutes. And they could have painted earlier on. They could have painted at 9 or even 8 o'clock that day, because the sun would have been out, and this never have occurred. And so the claim there was they were negligent by choosing the wrong time to paint. But that claim didn't survive to the jury, because Texas law says to claim negligence as well as premises liability, pretty much the painter would have had to been there physically painting while she walked onto the wet paint. And so the burden is really high. And in a premises liability standard, you have to prove all these different things. You have to prove that they knew or should have known that there was a dangerous condition, which, of course, in this case, they knew because they painted it. And we had to prove that they knew that the condition was dangerous, which, of course, it was, because it was wet paint on top of cement. And then we had to prove that they both failed to adequately warn and failed to adequately prevent the injury. Well, the adequately warn was the big issue in this case, because they had put out a cone, but we argued that the cone was insufficient because of multiple of reasons. But they fought us tooth and nail, because they felt, hey, we did all we had to do, and all we had to do was the bare minimum under the law to meet the burden for the law. That was their position. The jury obviously felt otherwise.
Congratulations. Job well done.
Thank you.
Andrew Traub has been our guest today. What a fine lawyer. What a fine interview. Andrew, is there anything else you'd like the viewers to know about you before we say goodbye?
Well, I would recommend viewers, if they want to learn more about us, to go to our website, which is austinaccidentlawyer.com. So Austin, the city, accidentlawyer.com. And we've got a lot of free reports and guides there. In addition, if they want to call us, our number is 512-246-9191. And we have Spanish-speaking people available if they are primarily Spanish speakers or prefer to speak in Spanish. And again, that number is 512-246-9191.
Well, there you have it, a great interview with a great lawyer. Thank you for joining us, and I hope to talk to you again soon.
Thank you.
This is Mike Gassaway for Legal Reader. I'll see you on down the line.